This program is brought to you by Emory University.
All right, thank you. Our first panel this morning is titled Creating Change, Advances in State and Local Election Law Approaches, and will be moderated by Professor Deborah Dinner. Professor Dinner is a legal historian whose scholarship examines the interaction between social movements, political culture, and legal change. Her research focuses on questions of gender and class equity in the legal regulation of the workplace and labor markets, family relationships, the hybrid public-private welfare regime, and insurance law. Her courses and curricular interests include property, employment discrimination, legal history, the 14th Amendment, and family law. Professor Dinner joined Emory in 2015 after serving as an associate professor at Washington University in St. Louis School of Law. Professor Dinner earned her JD and PhD in history at Yale. Following law school, she clerked for Judge Karen Nelson Moore of the U.S. Court of Appeals for the Sixth Circuit and served as the Raoul Berger Mark DeWolf Howe Legal History Fellow at Harvard and the Samuel Goley Fellow in Legal History at NYU School of Law. Please join me in welcoming Professor Dinner.
Thanks so much to Rashmi and Will and the members of the ELJ for organizing this really exciting symposium, an important one today. It's truly just my honor to introduce these illustrious panelists. Our first speaker is Richard Briffault, who is the Joseph P. Chamberlain Professor of Legislation at Columbia Law School. Professor Briffault's work focuses on state and local government law, the law of the political process, and government ethics. He is chair of the New York City Conflicts of Interest Board, was a member of New York's Moreland Act Commission to investigate public corruption, and is the reporter for the American Law Institute's Project on Principles of Government Ethics. He was a member of or consultant to several New York City and state commissions, including the State Commission on Local Government Efficiency and Competitiveness, the Temporary Commission on Constitutional Revision, the Real Property Tax Reform Commission, and the New York City Charter Revision Commission. Before joining the Columbia faculty, he was assistant counsel to Governor Hugh Carey of New York. He is co-author of the textbook State and Local Government Law and The New Preemption Reader, and author of Balancing Acts, The Reality Behind State Balanced Budget Requirements, as well as more than 75 law review articles. Our second speaker is Brian Sells, who is homegrown and home living and right around the corner in Atlanta. He's a civil rights lawyer in the law offices of Brian L. Sells, LLC. Attorney Sells is a private practitioner specializing in voting rights, election law, and redistricting. He has represented parties and amici in numerous election-related lawsuits, including several cases decided in the United States Supreme Court. He has a truly stunning list of cases and variety of election law that he's worked on, and I'll just name a few notable cases. So some of these include Georgia Coalition for the People's Agenda versus Kemp, enjoining Georgia's proof of citizenship requirement prior to the 2018 election, Wright v. Sumter County Board of Elections and Registration, finding that school board election plan diluted African American voting strength, United Utah Party versus Cox, enjoining ballot access limits in a special congressional election, several cases along these same lines, at least two cases looking at how elections diluted Native American voting strength, and then last, Quiver v. Nelson, enforcing Section 5 of the Voting Rights Act. And our third speaker is Abby Wood, who is a professor at the University of Southern California Gould School of Law. Professor Wood's research is at the intersection of law and politics. She uses quantitative analysis to examine the causal effects of institutional changes on human behavior. Her current projects analyze what voters learn from campaign finance disclosures, whether transparency can affect donor decision-making, and patterns in congressional oversight of agency activity. Recent projects examine the Freedom of Information Act and agency politicization, regulating false political speech on social media, and the effects of Citizens United on political donors. In addition to teaching at USC, Professor Wood has taught at the University of Chicago Law School. From 2015 to 17, she served on the Federal Bipartisan Campaign Finance Task Force. And before joining USC Gould, Wood clerked for the Honorable John T. Noonan, Judge of the Court of Appeals for the Ninth Circuit. So please join me in welcoming these wonderful panelists.
Yes, I should start, and we'd speak from here, right? Yeah, so sort of two preliminary thoughts. First, I want to thank the symposium organizers for how incredibly well organized and hospitable you are. When we invite people to Columbia, you get off the plane and they said, you know, there's the taxi line, come. And here people, or somebody picked me at the airport, picked up this morning, and people have been incredibly hospitable. Second is sort of just reflecting on Mr. Bondurant's speech. Professor Wood and I were sitting together, and sort of towards the end, we were sort of like, so why are we in this field? Isn't this really depressing? You know, maybe we should do something more cheerful, like trust in the states. And it's like, it is true. I've been in this field for a long time. I was talking with Brian a minute ago, and a long time ago it seemed a lot more upbeat. And now it's like sort of one disaster after another. But my talk will be, I would say, moderately upbeat. You can't be too upbeat in this world anymore. But my focus is going to be on what's going on. It's kind of a general overview and some comments on what's going on at the state and local level, where actually a lot is going on, and although some of it is not so good, and we may hear more about that, I'm going to kind of be, I'm in the glasses half full department, acknowledging some of the empties. So I'll begin by saying, and as it also relates to the fact, as you could tell maybe from the introduction, a lot of my work is, I kind of work at the intersection, or maybe the overlap of state and local government law and election law, and so it's sort of natural I want to focus on some of the things that states and locals are doing. It should be no surprise that states and locals are very actively involved in writing and in election law. The Constitution leaves the process of managing federal elections to the states, subject to possible federal legislative interventions. The states, in turn, delegate much of that process of actually running elections to local governments. States and local governments are responsible for the rules governing their own elections, subject to limited, albeit significant, federal constitutional and statutory constraints. Given that there are 50 states and thousands of cities and counties that conduct elections, state and local election regulation, variations among states and local rules, and state and local electoral innovation is all but inevitable. There appears to be a lot going on in particular lately. State and local governments have adopted state constitutional amendments and state and local laws addressing who can vote, the administration of the registration and voting processes, how votes are aggregated, how legislatures are to be apportionment, and how campaigns are financed and campaign finances are regulated. State courts interpreting state constitutional provisions have been a part of this process. And at a time of national deadlock and discontent on a host of electoral issues, states and local governments have been seen by some, and in some areas actually are, beacons of reform. I'm going to talk briefly, or maybe with 18 minutes worth, of some of the areas in which states and locals have been active. Again, probably emphasizing more the progressive innovations, but I will note some of the ways in which states and locals have been regressive. I'll talk briefly about some of the constraints that operate on states and locals, federal constitutional doctrines, and for the locals, the possibility of state preemption. And then maybe at the end, I will give a sort of a brief summary of some of the benefits, costs, and limitations of state and local activism. So to begin on state and local innovation, there is a long history of this. Long before the Supreme Court took on wealth or tax payment qualifications for the franchise, some states at least were reducing or eliminating them on their own. Some states, it was all emphasis on the some, and local governments were extended the franchise to women before the ratification of the 19th Amendment. And states and local governments have long experimented with devices for aggregating votes like cumulative voting, limited voting, and proportional representation. And while, of course, recognizing that many of the worst aspects of our system, like the poll tax, literacy tests, the grandfather clause, burdensome registration requirements also came out of the states. So we really do have to see both parts of the picture. Focusing on what's going on now, and I'm really going to talk about 5 topics. The first is registration and voting. A number of states have sought to make it easier for people to register and vote. 18 states and the District of Columbia have enacted some form of automatic voter registration, or AVR, nearly all in the last 4 years, although not all of these have taken effect. These, to some extent, build on the so-called federal motor voter model that was adopted in 1993, which basically said that when you come into contact with state agencies, usually the DMV, they're supposed to tell you about give you opportunity, give you voter registration forms. Modern AVR of the last 4 years has kind of switched from opt-in to opt-out, and using various mechanisms, either doing it right there or by sending you a postcard. In effect, if you come into contact with state agencies, usually the DMV, but some states broaden that, you will be registered to vote unless you choose not to. This has the advantage of removing barriers to registration. Voters don't have to worry about registration deadlines or application submissions. It reduces the cost of provisional ballots. I think the jury is not yet in as to whether or not this has led to higher turnout, and I think political scientists disagree. So far, the states that have used it have reported positive outcomes, but it could be, as you know, the states that choose to use it are the states that might have positive outcomes, so we don't know. But it is a striking development, given that voter registration is one of the ongoing deep-seated burdens on voting in the United States, that at least some states are taking a more active approach. Many states have also moved to facilitate the voting process. 39 states in the District of Columbia have implemented some form of early voting, with 2 more states having adopted it, not yet implemented it. As many of you know, many of you may vote early. It's a way of enabling people to vote either in central locations or in state, county, and local offices. It could also be grocery stores or shopping malls, schools and libraries in advance of Election Day. Most states will mail voters an absentee ballot, but now 5 states, Colorado, Hawaii, Oregon, Utah, and Washington, have adopted all mail elections, although Hawaii and Utah are quite recent in doing so, so we don't really know how well that's going to work. And Utah has also given local jurisdictions the choice of whether to hold their local elections by mail. In 2018, 27 of 29 counties chose that. 19 states allow certain elections to be held by mail. Again, these things are relatively new developments. We do not know yet how well they will boost turnout, or rather I can say to you multiple conflicting studies on this. Some say yes, some say no. We may not know yet. Maybe the best argument for it, if you doubt whether turnout overall is being increased, is the idea that it's at least going to reduce the chaos on Election Day and make Election Day a less unpleasant experience for those people who are actually voting on Election Day. If a lot of people get to vote before, there will be fewer stresses on the system. Lines will be shorter. Poll workers will perform better. There may be fewer mistakes. So maybe we'll get bigger turnout. We may at least get a more efficient operation. So that was registration and voting. A second area where there's been a lot of innovation is kind of how we count the votes. And by this, I'm referring to the growth of ranked choice voting. For here, some of you know all about this. For others who don't, I'll be a little more technical about it. The most common method of counting votes in American elections is so-called first-past-the-post, FTPT, plurality voting. That is, when multiple candidates run for the same office, the person who gets the most vote wins. That sounds fine, except when that person does not have a majority. When it's a plurality winner, if you have 3, 4, 5 candidates, and the person with 35% comes in first, may still win. That could be a problem, for example, if there are multiple factions in the community. The larger faction has multiple candidates, the smaller faction has one. The candidate of the smaller faction may win. It also presents problems for third parties and independents. There's a concern that they will be treated as spoilers. Maybe somebody on the Green Party runs and is going to siphon off votes from the Democrats, or somebody who's a libertarian runs and siphons off votes from Republicans. This may have the effect of suppressing the actual vote for these other groups, which may have significant support in the community but are not getting the votes because of the spoiler concern. One way to address this is, of course, to have runoffs. Require that there be a majority winner, but runoffs are costly. Voter turnout in runoffs is usually lower, and so the runoff may not be a perfect solution. With ranked choice voting, voters are asked to rank their choices, as the name implies, when they go to the polling place. If one person still gets a majority of the votes, that person is still elected. If no one gets a majority, basically the bottom candidate is dropped out and that person's second place choices are redistributed to the remaining candidates, and we keep going until there's a majority winner. This assures that the actual winner has the broadest support, even if he or she didn't come in with a plurality. It actually removes the discouragement from people for voting for third party or independent candidates, because their votes will still count if their person doesn't win. And there isn't an otherwise majority winner. They'll be counted on from their second choices. And some have argued that RCV, ranked choice voting, promotes civility in election campaigns, as candidates have less of an incentive to slam the opposition and more of an incentive to reach out to voters to get them to get their second or third choices. Ranked choice voting has actually been around a long time, and a number of communities used it in the United States in the late 19th and early 20th century, but its support dwindled in the course of the mid-20th century, and by 1962 it was only one place, and in honor of our morning speaker, I'll refer to it as the People's Republic of Cambridge, Massachusetts. But actually, in the last 20 years, it's had a comeback, particularly at the local level. And 24 cities now, in a dozen states, now use ranked choice voting for some or all of their municipal elections, including San Francisco and Oakland, cities in Colorado, other cities in Massachusetts, Minneapolis and St. Paul. Last November, my city, New York City, adopted ranked choice voting for municipal primaries. At this point, there's only one state. Maine has adopted ranked choice voting, and as a result of some of the more archaic provisions of the Maine Constitution, it's going to be used for all federal elections, but only for primaries in state elections. In 2018, it actually determined the result of a congressional district in Maine, where the candidate who came in second in the first round with about 48% of the vote became the ultimate winner when the second choice votes, when the bottom candidate's votes were redistributed and that candidate came out ahead. And in 2018, Colorado, New Mexico, and Utah adopted local option ranked choice voting. So it is a reform which is beginning to kick around, and it is something worth thinking about. So third is redistricting. We've already heard a lot about redistricting and about Rucho. Mr. Bondurant, I'm not sure if he referred to this, but one of the, perhaps I would say, as if to take the sting out of his decision, the Chief Justice in Rucho pointed out that there are other avenues for addressing gerrymandering, including state activism. Right now, 8 states have commissions which give primary responsibility for redrawing their congressional districting plans. Technically, there's 9. The 9th is Montana, but which only has 1 district, so it doesn't really that relevant. But if Montana should grow, it would become relevant. 14 states have redistricting commissions for their state legislatures, with 6 more having so-called backup commissions if the legislature is unable to. 6 more have advisory commissions, and 5 have backup commissions. And while some of these commissions look a little bit more like just surrogates for the state legislature, with the 2 legislative leaders basically appointing people there, and it's kind of the same political process as we might have seen in the legislature. A handful, including California and Arizona, which are older, and Colorado and Michigan, which just voted them, have come up with creative mechanisms for trying to broaden the pool of people who get appointed to these commissions and to make these commissions somewhat more detached from the regular political process. In addition, as you did hear, state courts have been active in this area. The Pennsylvania Supreme Court, we heard about the intermediate courts in North Carolina. In these cases, they may be applying not just new measures that were adopted to address redistricting, but much older provisions, such as the state's equivalent of the First Amendment, or in Pennsylvania's case, the free and fair elections provision, which has been in the Pennsylvania Constitution since the beginning. And again, local governments have been active here. Again, and I'll point to my own city, New York City, we do have an independent redistricting commission for the city council. Finally, in the terms of the areas of progressive innovations, we'll talk about campaign finance. 2 areas in which states and locals have been positively active are public financing and disclosure. We'll hear a lot about disclosure in a few minutes, so I'll say very little. But in public financing, as you may have forgotten, the United States technically has a public financing provision for elections to the presidency. No one of any significance has used it in 2008 for a variety of reasons, mostly because there's not enough money, and in the primary system, the money is provided too late. There's never been public funding for congressional elections, but right now, at least 14 states provide some form of public financing for some state offices, and a dozen local governments, including New York City, Los Angeles, and Seattle, have them for local elections. These systems take a variety of forms. Some of them are so-called clean money programs, where the participating candidate basically raises a certain threshold amount and then says, I will only take government funds. That's, I think, the model that's in place in Arizona and Connecticut and Maine. Others use matching funds, built off the original idea of the primary system, the federal primary system. You raise a small amount of, you raise small dollars, they get matched. But New York City, in doing that, has over time set a new model of so-called multi-match. Instead of dollar for dollar, you might get two public dollars for one, or 4 public dollars for one, for up to, say, $250. New York City has moved to $6, and we recently moved to $8 for one for smaller donors. Not everyone thinks that's the right number. There's no necessarily right number, but there have been studies of this, and systems in Maine, Arizona, Connecticut, New York, Los Angeles have all been credited with increasing the competitiveness of elections, increasing the number of candidates being able to run for office, diversifying the candidate pool, expanding voter participation, and reducing the burdens of fundraising. In New York City in particular, the system has very high support. In 2017, 84% of the candidates in primaries participated, including the candidates for all 3 citywide posts and 4 of our 5 borough presidents. The newest innovation under the sun, and Abby and I were talking about this earlier, is vouchers, which is the idea that instead of the matching system still requires candidates to raise money, and it still requires some decision on the part of the city or state to decide who's qualified to get the money. With vouchers, the money goes to us, the voters, who then decide who are then free to send on their vouchers, say typically say you might get 4 $25 vouchers to give to qualifying candidates. Candidates give them candidates, and they can then cash them in for money from a city or state. Seattle first adopted this through local initiative in 2015, used it in 2017 for 2 citywide at-large council races and the election for city attorney. The winning candidates in all 3 races qualified for vouchers, as did the principal runners-up in the council races, and the vouchers accounted for a majority of the total contributions in those council elections, and a majority of the contributions to the winners in the city attorney races. Again, the people who have studied this have praised it. Of course, the people who study this tend to be people who like it, so we may not yet have received the full independent assessment. But one thing that is pointed out in both the New York City system and Seattle is that the sources of contributions are now far more equitably distributed amongst the city's neighborhoods. Typically in other systems, the richest neighborhoods, the top zip codes that by median income are usually the primary sources of money for local candidates. This becomes much less true either for the matching fund system or the voucher system. I'll only speak briefly about disclosure. States and local governments have been very active in revising and strengthening their disclosure laws, with particular attention to the issues presented by so-called outside groups. That is, committees not formally connected to a candidate or party, but that spend heavily in order to affect electoral outcomes. There are reasons. Most older disclosure laws don't cover them for a variety of reasons. Their spending might not be considered electoral because of relatively narrow definitions of what's electoral, or the group might not be considered primarily electoral because it has some mixture of electoral and what may be called general political spending. Many states and some cities, Portland, Oregon, Santa Fe, New Mexico, among the states, California, New York, Delaware, Illinois, have passed laws expanding the definition of what's considered electoral, or expanding the categories of groups that are covered to include some which may not be primarily electoral, but engage in a threshold level of electoral spending. And a number of states and cities have also passed laws that require that in the ad itself, the top donors to these groups, the top 3 or the top 5, be mentioned. That's the positive. I've given myself 3 minutes to mention the negative and everything else. So I'll just say in bullet points, let's not forget the negatives. Voter ID, of course, has become famous and or notorious. There did not used to be government-issued voter ID. I think before about the late 1990s or 2000s, either no states or hardly any states required a so-called government-issued voter ID in order to be government-issued photo ID in order to vote. It has now become quite widespread and is present in something like 36 states. Gerrymandering, all those gerrymandering reforms wouldn't be so significant if there wasn't so much gerrymandering. And of course, as the gerrymandering has become much more creative and effective as a result of big data and the ability to run the 20,000 runs that Mr. Bondurant referred to. Of course, challengers can run them, but of course, so does the state legislature. And the records in cases like Florida, Maryland, Michigan, North Carolina, et cetera, tell us just how far the legislatures are willing to be partisan. And finally, campaign finance. Some states have limits, and some states have no limits on campaign contributions. 10 states have no limits. Some states have cut back on disclosure, and the South Dakota legislature actually repealed a public funding initiative that the voters had adopted, and Florida is currently talking about cutting back on local initiatives in disclosure. I'm going to skip over the limits stuff that I was going to talk about because I think the short answer is that actually federal constraints have not been a big part of affecting what states and local governments can do in the areas I've mentioned. The main area where they are relevant, I think, is in campaign finance, but those are the kind of limits that apply to everybody, Congress as well as states and locals. The one issue where I think states and locals have tried something different and have generally been shut down is efforts to limit out-of-state or out-of-city contributions, either outright, which I don't think anyone has tried, but to say that out-of-state donors cannot give more than a certain amount, or more commonly, in-state candidates can't accept more than a certain amount or a certain fraction of their money from out-of-state donors. Alaska, Hawaii, Vermont, and Oregon have all adopted laws on this. All but the Hawaii one has been struck down. The Hawaii one has been struck down because for some reason unknown to me, it hasn't been challenged. And I would expect that if it is actually challenged, it would be struck down. So let me just say, I think I just hit my time limit, but I know I'll be indulged to take 2 more to give a quick summary. So what does it all mean? One is we are truly a federal system. Even federal offices are filled by elections subject to state voter registration, election matching, and apportionment schemes, and are implemented by local boards. Federal reforms have to run the gauntlet of state and local implementation, something I haven't spoken about, but that's a live issue. And state and locals have considerable discretion to shape the franchise and the voting processes and the aggregation systems for themselves. There's federal laws out there. There are federal flaws for certain things that states and locals can't go below, but they leave room for a lot of discretion. Second, states and locals are not consistently progressive or regressive. We should be long past the idea that civil rights and democracy protection is a congressional and Supreme Court matter. The feds don't have a monopoly on good deeds, and it often seems the opposite. Some states and locals engage in progressive innovation, and some do not. And I don't think it makes sense to give a positive or negative valence to either any level of our government. They're all willing to do things. Third is the states and locals have been active in a way that I think we've seen very little real activity at the congressional level. Part of this, I think, is for the local level, unicameral legislatures, the role of voter initiative, and even at the state level, more so-called trifectas. We are now at the stage where 49 of the 50 states have the same party holding both houses of the legislature, and something like more than 30 of the 50 states have both houses plus the governor all of the same party. Until very recently, it was overwhelmingly Republican. Now it's a bit more Democratic, but for better or for worse, that means you're going to see more activism. Next to last, laboratories of democracy. That phrase is used a lot, going back to Brandeis in the 1930s. We're actually seeing it. And there's a lot to learn. There's a lot, all the systems I mentioned, AVR, early voting, mail-in voting, voter ID, districting plans, public funding systems, all the states are doing them. They're all doing them a little bit differently. And so it's a lot to study and a lot to see what works, what doesn't work so well, what might actually have perverse consequences. Should it ever come to pass, possibly not in my lifetime, that Congress actually wants to do some of these more progressive things. And even the non-progressive states want to do more progressive things. There are some models to work from. Finally, again, maybe it's the first point all over again, federalism is just hardwired into the system. It's neither a strength nor a weakness. It is not a bug, it is a feature. And I think the challenge for all of us as scholars, as advocates, as litigants, as citizens, is to take advantage of the pluses while either accepting or controlling the minuses. And I think I'm only 3 minutes over, which is pretty good for me. Thank you.
Good morning. I also want to thank the Emory Law Journal and the symposium organizers for inviting this humble practitioner into the rarefied air of an academic symposium. This is the first one I've done, but I also want to say when I accepted this gig, I thought, wow, a symposium where I could actually walk there. I live just on the other side of Emory Village, but the weather didn't cooperate this morning, so. All right. I want to begin this morning with a quick survey. Just by a show of hands, how many of you have ever cast an absentee ballot, which is also known as a vote-by-mail ballot or a vote-at-home ballot? Looks like most people in the room. Okay, next question. How many of you cast a vote-by-mail in the 2018 general election? Show of hands. All right, not quite a quarter, I would say. So you're a little bit behind the curve. Voting by mail has more than doubled in the last 15 years, going from about 12% of votes cast in 2004 to 25% of votes cast in 2018. That's why you're a little behind the curve. That 25% figure translates into 31,058,968 vote-by-mail ballots. For those of you, the few of you in the room who haven't yet voted by mail, let me briefly explain how it works. And the process varies quite a bit from state to state, but the general process at a high level is this. A voter receives a paper ballot before Election Day, usually in the mail. The voter then fills out the ballot in the comfort of her own home. The voter then returns the ballot to election officials, usually by mail, but sometimes by placing the completed ballot into a special collection box that looks a little bit like a mailbox or a library book return. At no time must the voter appear in person, either at a polling place or an election office. And that's one of the reasons why so many voters like voting by mail. It can be ultra convenient, but that's also one reason why voting by mail presents unique security issues. And today I'm going to talk about one of those security issues. How do election officials verify that an absentee ballot received from a voter by mail or through a collection box was actually cast by the intended voter? There have been a number of advances in state and local approaches to this issue in recent years, and some of those advances were spurred in part by litigation in which I had the privilege to play a small role. The most common method of verifying that an absentee ballot comes from the intended voter is called signature verification. When a voter fills out the absentee ballot, she places the ballot in a security envelope and then signs an affidavit that is pre-printed on the outside of the security envelope. Election officials then compare the affidavit and signature to documents in their files when they receive the ballot. And that's usually the voter registration record. If the signature matches, the vote is counted. If the signature doesn't match, the ballot may not be counted. 36 states use signature matching in some form to verify absentee ballots. The remaining 14 states fall basically into two camps. The first group, which includes 9 states, only checks to make sure that the affidavit on the outside of the security envelope is completed and accurate. It may, for example, ask for the voter's date of birth or address or some kind of an ID number, and election officials in those states generally only check to make sure that that data is correct. The second group of 5 states requires that the voter's affidavit be signed in the presence of a witness, or in some cases, 2 witnesses, or a notary, or some other authorized person. And those states generally only check to make sure that the affidavit and witness signatures are filled out. So how effective are these methods of verifying absentee ballots? On the one hand, there's no evidence that fraudulent ballots are routinely evading these verification techniques. The Conservative Heritage Foundation has documented only 202 cases of alleged absentee ballot fraud nationwide since 1993. Available data show that high vote-by-mail states have no higher and often lower cases of absentee ballot fraud per capita than low vote-by-mail states. On the other hand, there is evidence that existing verification techniques result in the rejection of a large number of ballots, not all of which are likely to be fraudulent. In 2018 alone, approximately 67,000 mail ballots were rejected because of a non-matching signature. Approximately 55,000 mail ballots were rejected because voters forgot to sign the ballot return envelope. And another 10,632 ballots were rejected because the voters returned their ballot without a witness signature in a state that requires a witness signature. Combined, a total of about 133,000 ballots in just the 2018 general election failed the verification process in some way. That's less than 0.5% of all ballots cast by mail, but it's enough in a closely divided electorate to potentially affect electoral outcomes. Is there room for improvement? Yes, absolutely. Not all ballot verification procedures are created equal, and they vary quite widely in quality. Factors that contribute to process quality include the following. Number one, who does the verifying? Is it one person? Is it multiple people working in teams? Are the verifiers professional election administrators, or are they temporary workers? Are the verifiers partisan? Are they nonpartisan? Or in the case of teams, are they bipartisan? And what training do the verifiers receive, if any? Number two, how many signatures are available for comparison, and how old are they? Does the verification process check against only one signature from the voter's original voter registration application, which could be decades old? Or are there more and more recent signatures to check against, such as those in other state databases like a driver's license database and prior absentee ballot envelopes? Signatures can change over time and vary based on a number of conditions, and having more signatures makes the process more robust. And number three, is there any process for curing signature problems? Does the voter have a meaningful opportunity to fix any errors? Can the voter be contacted promptly? And is there enough time for the voter to take whatever steps are necessary to cure any defects? The election administration community has developed best practices in each of these areas, but implementation has been sporadic. That's where the litigation comes in. In the last two election cycles, there have been significant lawsuits aimed at ballot verification procedures in California, Florida, Georgia, Iowa, and New Hampshire. All 5 suits targeted those states' notice and cure provisions, and all 5 were decided in the plaintiff's favor. 2 of the 5 were decided based on substantive due process, essentially finding that the state's notice and cure provisions imposed a heavy and unjustified burden on the fundamental right to vote. And 3 were decided based on procedural due process grounds. Time doesn't permit me to go into detail on all 5 cases, but I do want to highlight the Georgia case because I think it's fairly representative of the others. Georgia is a no-excuse absentee ballot state. Any eligible voter can cast an absentee ballot for any reason or for no reason at all. The process, as it existed in 2018, consisted of 2 steps. First, a voter would submit an absentee ballot application by mail, fax, email, or in person. And when the application was received, election officials determined whether the applicant was, number 1, eligible to vote in the relevant primary election, and then election officials checked the voter's signature against the signature in the voter registration record. If election officials determined that the signature on the application did not match, they were required to notify the applicant promptly in writing. Now, I say election officials, but the fact is that Georgia law did not require more than one person to verify or reject an absentee ballot or an absentee ballot application. And it did not require or permit any bipartisan oversight. County election supervisors are not elected in Georgia, but they are hired by and accountable to partisan county elected officials. Georgia law did not require the person or persons reviewing a signature to undergo any training on signature verification, and in fact, no such training was even offered by the Secretary of State's office. Georgia's election law grants a great deal of discretion to county election officials, so it was up to each county to decide who would do the review, what training that person or those persons would receive, if any, and what standards they would use in accepting or rejecting an application. While Georgia law did require notice to the voter, it was up to each county to determine what prompt notice meant. In Gwinnett County, which was the main target of the lawsuit, prompt notice consisted of a single notice letter sent by first-class mail within 3 business days after an application had been rejected. Georgia law provided no opportunity to cure a rejected application, but a voter could reapply if there was at least 2 days before the election. That's the cutoff under Georgia law for applying for an absentee ballot. Now, if a voter's application for an absentee ballot was accepted, election officials would send the voter a ballot. The voter had to sign the oath printed on the envelope, and then upon receipt of the ballot, the election officials either accepted or rejected the ballot. Same process all over again. They were again required to give the voter prompt notice of a rejection, but again, there was no cure period. A voter could either vote in person or go back to step 1 and reapply for an absentee ballot if there were at least 2 days remaining before the election. One final factoid about the Georgia case. The plaintiffs alleged that, at least in Gwinnett County, absentee ballot rejection rates varied widely by race, with African American and Asian American ballots being rejected at much higher rates than ballots submitted by white voters. Now, as I've already mentioned, the district court ruled in the plaintiff's favor and granted a preliminary injunction just before the 2018 general election. The injunction essentially prohibited local election officials from rejecting absentee ballots and absentee ballot applications due to signature matches. And the judge required instead that officials treat those ballots and applications as provisional ballots, subject to the state's existing cure provisions for voters who cast a provisional ballot in person at the polls, such as when a voter doesn't bring one of the required forms of photo ID to the polls. So, for example, if an official were to determine that an application signature did not match, they were still required to send the voter an absentee ballot, along with notice about the cure process, and the ballot would be marked as provisional. If the voter returned the ballot, the signature would again be checked, and if there was still a mismatch, notice would be sent again to the voter, and the voter would have until three days after the election to cure the defect. Any decision on the provisional ballot was also subject to appeal to the full county board of elections. The Secretary of State, Brian Kemp at the time, sought an emergency stay of the district court's injunction in the 11th Circuit, but the panel denied the stay request by a 2-to-1 vote. The appeal became moot after the election, but notably, the 11th Circuit 4 months later issued an opinion on its decision to deny the stay because the dissenter, Senior Judge Joe Flatt, wanted to publish his views on the matter. Judge Joe Flatt, in dissent, would have granted the stay and reversed the district court for 3 reasons. First, he would have denied the plaintiff's facial challenge, requiring them instead to bring an as-applied challenge. Second, he would have denied even an as-applied due process challenge because the plaintiffs could have sought relief in state court, and he concluded that that was all the process to which the plaintiffs would have been due. And third, he would have also reversed because, in his view, the remedy itself violated federalism principles and the Equal Protection Clause in a Bush versus Gore kind of way. In Judge Joe Flatt's view, the only constitutionally permissible remedy would have been to enjoin enforcement of Georgia's absentee ballot laws in their entirety, meaning that no one would be allowed to vote by mail. To date, this is the only appellate court opinion on the issue. Following the 2018 election, the Georgia General Assembly, at its 2019 session, essentially enacted the district court's remedy into law. And in administrative rules adopted just last month, prompt notice now means within 3 days after the absentee ballot application or absentee ballot is received, not within 3 days after the ballot was rejected, as was the practice in Gwinnett County. And election officials are also required to try to contact the voter by phone and email if that information is available, in addition to sending written notice. So as a result of this litigation, Georgia now has a much improved notice and cure provision and at least some possibility of review by more than one person. It's not at all perfect, but it's certainly progress. Florida also adopted similar laws in 2019 following the successful legal challenge there. Now, in addition to advances brought about by litigation, there have been other advances at the state and local levels made through legislative and regulatory channels, and I want to briefly highlight just a few of those. First, Colorado. As we heard from Professor Briffault, Colorado has a vote-by-mail system, and it is now the gold standard for ballot verification. Colorado requires multiple layers of review before a ballot is rejected. The largest counties use verification software to assist in the initial reviews and statistical audits to verify the accuracy of the automated verification process. It requires bipartisan teams at the upper levels of review, and the state has produced a 20-page signature verification guide complete with a quiz at the end. Colorado also allows for multiple exemplar signatures for comparison, and it provides a cure period that extends 8 days after Election Day. Oregon, which has been a vote-by-mail state for 20 years, is not far behind. Oregon requires that anyone verifying signatures receive extensive training, and the state provides detailed guidelines for evaluating signatures. And it provides a cure period that extends for 14 days after Election Day. Denver, Colorado, a locality, has been really innovative. City election officials developed a web-based system called Ballot Trace, which is an acronym that stands for Ballot Tracking, Reporting, and Communications Engine. And by using that tool, voters can monitor their ballot at each point in its journey before and after they cast their vote. They can see when their ballot is printed, when it is on their way to them, when it is delivered, when it is on its way back to elections officials, when it is received, and when it is accepted. It's very similar to tracking an Amazon order. We all get those texts now, or notifications on your phone. Well, you can be annoyed by your absentee ballot status just as well. And if there's a problem with signature verification, you can see that on Ballot Trace even before you get the official notification from the city. There's a nonprofit organization called Democracy Works, which has developed a similar tool called Ballot Scout that is starting to take off outside of Denver. In 2018, Ballot Scout tracked almost 3 million vote-by-mail ballots, or approximately 8% of the mail ballots cast in that election. Both systems allow voters to be notified by phone, text, or email. And finally, in 2018, in Arapahoe County, Colorado, which is in the Denver suburbs, they launched a new text-to-cure program using a tool called TXT #2 vote. And with text-to-cure, voters can send a text message containing the word Arapahoe to the number 2 and VOTE, and they receive back an automated but secure web link. By clicking on the link and entering an assigned PIN number, the voter can sign a verification affidavit and upload a photo of their identification, and the entire cure process takes less than 1 minute. I want to close with just a few thoughts about how ballot verification issues might affect 2020 and beyond. First, I see no major legislation on these issues thus far in 2020, but many legislatures are still in session, so that could change. Second, there is new signature matching litigation pending in Michigan and Indiana. The former was brought by Priorities USA, a left-leaning advocacy organization, and the latter was brought by Common Cause, which is also a left-leaning advocacy organization. Both of these suits challenged the lack of a cure period in those states, and I expect that both will be resolved in some fashion before Election Day. And finally, I would not be surprised to see more litigation emerge as Election Day draws near. More than 30 states lack any formal signature curing process, and a number of those could have close presidential or senatorial elections, including Alabama, Kentucky, Maine, North Carolina, Pennsylvania, South Carolina, and Texas. Beyond 2020, I see a small glimmer of hope. Just last month, the Bipartisan Policy Center's Task Force on Elections released a fantastic report setting forth a number of recommended election best practices. The task force consisted of a diverse collection of state and local election administrators from across the nation, including Georgia's own Kevin Rayburn, Assistant General Counsel to the Secretary of State. The report contains 2 recommendations regarding ballot verification. Number 1, states should collect additional points of contact, such as the voter's email and cell phone number, that can be used to contact the voter quickly in the event of discrepant signatures. And number 2, that states should allow a cure period for vote-by-mail ballots, even if the period extends beyond Election Day. These recommendations are not likely to be adopted everywhere overnight, but the report is evidence that bipartisan election reforms do exist. My hope is that the report and its recommendations, along with some of the exciting technological solutions that are still emerging, will begin to nudge states towards better ballot verification policy in the years ahead. Thank you.
Are we up? We're up. Hi. Is this, I don't know if we're on. Oh, we're on. Okay. So I also want to thank the fine people of the Emory Law Journal for the invitation to come back to Atlanta. It's great, of course, to be among scholars I've long respected, but also among practitioners whose work I love to learn about and learn from. It's also really nice to be back in a place where when I ask for iced tea, I am asked if I want it sweet or unsweet. My PhD is in political science, and so what I like to do is look at questions in the jurisprudence. There's a bunch of empirical assumptions in campaign finance law. The court just says that things are true in the world that have never been tested, and so I basically have spent the last, 10 years testing some of their assumptions. So today what I'm going to focus on is the informational benefits of campaign finance disclosure. The court assumes they exist, and I'll talk about what I've learned in my work. I've also done some work on the costs of disclosure, but that's not what I'm going to talk about today. Happy to talk about that in the Q&A if you'd like. Okay, so just to give a little background, like before we get to disclosure, we have to talk broadly about how we think about campaign finance, or how the court has addressed it. So it has become constitutionalized. That didn't have to happen. It could just be a statutory issue that the court resolves over and over, but instead the court, 40 some odd years ago, decided that political spending is protected speech under the First Amendment. And so what that means, of course, for everyone in the room would know this, right, that now we're doing strict scrutiny. And so that means that anything that states or local governments or the federal government tries to do to limit or ban or otherwise regulate that speech has a tough go of it in the courts, okay? So a lot of the push to strike down this stuff has been under this rubric, I would guess, or this rhetorical device of saying we should deregulate and disclose, okay? So up here we have, I'm not gonna walk through them, but just, you know, on the left we have the limits that have been tried at the federal level. I don't even think it's a complete list, right? On the right we have the bans that have been tried. And just since Buckley v. Vallejo, right, those are the ones that have been struck down. And I don't even have disclosure up there, okay? So disclosure usually is upheld. And so the cry from those who've been challenging these laws has been, don't limit, don't ban, just give the information. Let's just do disclosure here. And so the court has kind of gone along with that. And here's an example, right, from Citizens United. The government may regulate, this was a case about corporate political speech, as you probably know, corporate political speech through disclaimer and disclosure requirements, but it may not suppress that speech altogether, right? So that's the kind of rhetoric that we get when we're in kind of deregulate and disclose mode. But of course, right, as our distinguished panelists has been saying for, you know, at least a decade, right? Disclosure in US elections is incomplete, okay? So we have, of course, dark money, which you've probably heard of, right? Dark money, it got this name after Citizens United because what happened was Citizens United, the majority opinion, right, it brought these new spenders into the system. So what that ended up looking like was 501c4s and LLCs, right? Unions can also do this, but we don't usually see the unions spending themselves. What we see is 501c4s and LLCs getting created. And what happened was, right, the FEC failed to regulate in a strong way, but also there were some budget writers put in the spending bills that prohibited the SEC and the IRS from also regulating because they might have been able to have an angle for shareholders or for the 501c4s to have to do more robust disclosure. And so what you have is new types of spenders with no disclosure requirements. Some disclose voluntarily, that's a very small group, but mostly we just have dark money, okay? So that's how that happened in case it's something you didn't know. Well, when dark money groups give to groups that are subject to disclosure, like super PACs, then what happens is we lose the money trail. So, I don't know, the Brennan Center calls this gray money. I've heard Common Cause call this the daisy chain. But anyway, we lose track of it, right? So I just had something in the Washington Post a couple weeks ago when Citizens United turned 10. And I had an example of $50 million, a super PAC that raised $50 million. It was in support of President Trump, and there were 5 donors, and 5 donors only, and none of them were subject to disclosure beyond that. So we couldn't trace the money beyond those 5 donors, right? And then we also have dark ads. I'm gonna get my water. Okay. Dark ads on social media. So, okay, I don't know how big of a problem this is, but it exists and it's part of the incomplete disclosure case, so I'm gonna tell you about it. The FEC has long had this kind of, you know, definition of political communications that now feels a little goofy, and what it exempts is political communications that are placed on someone's own page or someone's own YouTube channel. Basically, we're only gonna regulate political communications online if they're placed on the website of another and for a fee, and that, you know, none of the organic content is like that. So what that means is they're not subject to disclaimer requirements, and, you know, there's not a lot of research on whether disclaimer requirements really matter. There's another piece of this, which is, of course, all the disinformation that was floating around in 2016. Facebook has not revealed that data to the political scientists that it promised the data to, but there was a very savvy woman in the communications department, or maybe the journalism department at Madison, University of Wisconsin-Madison, who was capturing them. Just as the election was going, she was capturing them. And one thing she found is that only 8% of the people doing any political speech online in this way that looked like ads or fake news, right, were actually FEC, like registered entities, right? So it's really hard for them to regulate that in real time. Again, we don't know how much of a problem this is, but I just want to point it out to you that like there's something going on social media and online that, you know, the platforms have stepped in a little bit, kind of at the margins to try to be more transparent, but, you know, kind of stay tuned for that. Okay, so what we also have going on now is a move from deregulate and disclose, where again, disclosure is not complete, to deregulate, period. So as I was preparing these slides, I was wondering, I know there's a new 501c4 group aimed at undermining campaign finance disclosure, okay? And what they have an ad running, I think, to suburban women that basically shows like the aftermath of a bombing of a Planned Parenthood site, and it says something like, aren't you glad Planned Parenthood's donors are not disclosed? Okay, well, Planned Parenthood, right, they have an action fund, right, it's a 501c4. And so they're trying to kind of get people to think more about donor privacy, and donor privacy, you know, has its place, right? But so I was trying to find that group, I didn't find it, but what I found is ALEC, right, the American Legislative Exchange Council, which, you know, is a right-leaning group, and they have created this donor disclosure legislative toolkit where they really are going right at donor disclosure. And it could be in part because some of the states are getting pretty innovative or energetic, at least, on improving these gaps in disclosure that we've been talking about. So just to show you that one page of this is all about anonymous giving, right? So does not the First Amendment protect the people's right to speech and association? Are you familiar with the NAACP versus Alabama case in which the US Supreme Court found that requiring the disclosure of donors to the NAACP would have created an unreasonable threat to their livelihood and their lives, right? I mean, this was the 60s. And therefore found that Alabama's law violated the privacy and free speech rights of donors to the NAACP. And then they're saying, like, doesn't this legislation threaten those same rights? So they're trying to draw this tie between exempting a very vulnerable group of people from disclosing their lists to exempting people from having to disclose their political donations. Okay, so this is the main move that goes on. It's all under the rubric of the First Amendment. Okay, so that's kind of the political context and kind of the, you know, stream of cases through the court context in which you can think about these things, okay? So now we move to what the court has identified as government interest in disclosure. These are, I'm gonna mention 3 interests. These are in Buckley v. Vallejo, and they're just repeated in all the subsequent cases, citing to Buckley, sometimes just quoting Buckley. It never gets much deeper than this. Okay? So the first one, the one they care most about, is deterring corruption. Okay? They have defined corruption as quid pro quo corruption only. So things like gaining additional access to your representative is not something that the court is considering corruption. Okay? They really want a very narrow definition of corruption. So here's how it was said in Buckley. When it comes to, this is particularly, oh, I'm sorry, let me just tell you. So when you think about quid pro quo corruption, you think about giving money directly, right, to the campaign or to the candidate, okay? But of course, a lot of money in campaign finance is this independent expenditure side of things, right? The super PACs, the 501c4s, the LLCs, a lot of them are doing this stuff, okay? So the problem with corruption as an interest, as a government interest, and something we're going to try to hang disclosure on, is that the court has undermined its relevance in the independent expenditure framework. Okay, so here's a quote from Buckley that has been repeated since. When it comes to independent expenditures, the absence of prearrangement and coordination alleviates the danger that expenditures will be given as a quid pro quo for improper commitments from the candidate. Okay. So this is based on a legal fiction. When we say that there's a group making independent expenditures, those expenditures are by definition not allowed to be coordinated. We have a ban on coordination. But you could drive a truck through the loopholes in the coordination definition. So if I tweet out that I have made an ad buy in Atlanta in support of Stacey Abrams' gubernatorial campaign, and I'm an outside group, her gubernatorial campaign knows they don't have to run ads in Atlanta for whatever week I'm saying I made the buy for. And that's not considered coordination because it's in public, okay? So the court has decided, well, these are independent expenditures, so we're not gonna limit them because the corruption we care about is the quid pro quo corruption, and because there's no coordination, because these are independent, therefore there's no one to take the quo, because the candidate simply is not involved in this process, okay? So that's why this interest I care about, the informational interest, is really important in the disclosure context, especially when it comes to independent expenditures, okay? So that's corruption. Enforcement, I just want to touch on. I don't know of any cases that have hung entirely on the enforcement benefit, but of course disclosures help us enforce the limits and bans that exist, okay? And so have you seen this guy, right? This is Lev Parnas, okay. With President Trump, of course. And so he was laundering, or he's alleged to have laundered foreign money through a dark money group. And of course it was a dark money group, and so how was there any disclosure? Well, there's a really clever lawyer at the Campaign Legal Center who was using anything he could to figure out where is this group coming from, what's going on here. And so of course you have to disclose your address right now when you make a direct contribution, and when the LLC is formed, it has to disclose an address, and guess what? The LLC's address was Lev Parnas' address. And so that gave him leverage to then start to figure out what else was going on, okay? So imagine, right, if we actually had disclosure of, for example, dark money, right, we would be able to enforce, especially the foreign national ban, a little bit better, okay? All right, so that's the enforcement benefit. Now finally we get to the one I'm talking about today. Sorry for the buildup, but it's important, right? So the informational benefit. So the court thinks of the informational benefit very narrowly. They think of it in one dimension, okay? And here's the way they talk about it. Campaign finance disclosure allows voters to place each candidate in the political spectrum, a spectrum is one-dimensional, right? More precisely than is often possible solely on the basis of party labels and campaign speeches, okay? So this is from Buckley. So here's what this actually looks like when political scientists get a hold of it, okay? So this is a distribution of Republicans in the 116th Congress, okay? Political scientists always just number the Congresses, and then you have to think like, oh God, which one are we in, okay? Anyway, it's pretty recent. Maybe this one, I don't know. Okay, it's not what I study. Okay, so this red distribution is, if you were to place all, of the Republicans along, along this line, you could stack them all up and you'd get up to here. This is kind of where the median one would be on a liberal to conservative scale. And this is based only on the donors to the candidates when they run as candidates. Does that make sense? So you run, you get a bunch of donations, those donations are disclosed, and then you're in office, and we can just look at your donors and predict how you're gonna vote on things, okay? So what he's done, this is Adam Bonica's work, he's at Stanford. So just to give a sense of where Trump lines up with everybody else, right? He's put, John McCain, I'll just go from left to right so I can stop looking back there. John McCain, Mitt Romney, George W. Bush, I think that's Steve King, Michelle Bachmann, David Duke. I don't know who Moore is, sorry. Oh yeah, that's right. The guy that ran for, was a Senate in Alabama, Roy Moore, right? Okay. And then of course Donald Trump, right? So based on donations, that's how these line up. okay? And Bonica has all this work showing that we can use only donations to predict floor votes, and it's actually more predictive for incumbents than their prior year's floor votes. So we really learn a lot of policy information from campaign finance disclosure, okay? So the court's right about that. My research shows that, you don't have to worry too much about the details here, right? It's mostly for, just to show you, that actually we probably have another dimension, if not more than one other dimension going on how voters are informed by campaign finance disclosure, people's kind of attitudes toward disclosure. So I've run some survey experiments, right? So this one is on a national representative sample of voting age respondents, about 1,500 people, and I give them a bunch of policies and other things that they might care about. So police, whether police can ask immigration status, right? Whether we have compulsory sex education, whether they're complying with campaign finance relationships, their relationship to dark money groups, how persuasive they are in public, their grasp of the issues, total amount raised, what their percent of small donors is, and then what their professional background is. You don't have to worry too much about that. Just know that they're seeing these randomly generated candidates, and then they have to choose one, and then they have to tell me how trustworthy they think that they are. Okay, and here's what we find. The respondents are less likely to choose a candidate that's supported by groups that don't disclose their donors. I don't use the phrase dark money, okay? That would be too triggering, right? And then they rate these candidates as much less trustworthy, okay? They're more likely to choose a candidate that discourages support from groups with anonymous donors, and they rate those candidates as more trustworthy. So they're learning something on this kind of trustworthiness dimension, okay? That's different than their policy dimension, right? I've run it a couple of different ways, okay? So the effects persist even when I give them policy information. They persist among Republicans and Democrats, which means that Republican elite rhetoric in this area, right? Mitch McConnell doesn't like campaign finance disclosure, hasn't yet affected the voters. We'll see how this new 501c4 does, though, with their Planned Parenthood ad. And it also persists, as some colleagues have found, in the general election context, when you actually have party cues, okay? But the effect is a little bit more muted there because party really matters, of course. Okay. Finally, extremists, people who rate themselves as very, very conservative, or I think that's actually extremely conservative and extremely liberal, they react the most. They're also the most engaged, right? Okay, finally, or additionally, I guess I should say, campaign finance compliance is also very important to voters. So my biggest effects in the prior study were actually on whether they had undercomplied or overcomplied with the law, okay? You need audits to be able to show this. Audits take some time, okay? So one thing that I found was with a co-author, right? Randomly assigned FEC audits after the 1976 election. Voters really reacted to that. Okay, violators were much more likely to retire anticipating the voter reaction, and violators had an 8 to 15 percentage point drop in vote share in the following election. So the voters punished them. Okay, this was random assignment, so we're able to say that anything else that might have caused them to lose vote share should be pretty evenly distributed between the groups, right? So this means voters care about this stuff. They're learning in the campaign finance domain beyond just policies, okay? So I argue that the court should give the informational benefit more weight. They should be much less, quick to talk about corruption and actually drill down a little bit on this informational benefit. Okay, so voters learn both policy information and what political scientists call valence information, non-policy characteristics, okay, from disclosures. It's particularly important where independent expenditures are involved, of course, for reasons I talked about before. What that means is that policymakers can consider more audits, right? So the New York City Campaign Finance Board does audits of everybody who takes public money. The FPPC in California, which is like the regulator in California, does random audits at all levels of government, okay? Other states could do this kind of thing to help make sure that whatever laws we have are being actually followed by the candidates. And then when it gets to the court should uphold that. That's important information for the voters, okay? Similarly, some of these transparency laws that shed more light on dark money, they are going to come under attack. But again, the fact of dark money is really informative to the voters, right? And we know that we gain information from the disclosures themselves. Finally, because the fact of dark money is so informative to the voters, you could also have something that Heather Gerken, the dean at Yale, has called disclosure disclaimers, where you can just put a disclaimer on the ad that says this ad was funded by anonymous sources, because voters are going to care about that. And then, because voters learn on this other dimension, the court should uphold it. So I'll stop there, but happy to talk about any of this in the Q&A.
Okay, so we have time for a couple of questions, and there's mics on both sides of the room. You can just line up. I can get us started if needed, but I want to give people time.
Okay to go? Thank you all for a wonderful presentation. Pardon me?
My question is for Mr. Sells. Oh, sorry. I thought you were concluding the session. You were like, thank you, everyone. You go first.
Yeah, go ahead.
My question is for all the presenters. You discuss the role of federalism and the innovations that states are engaging in. And in many cases, there are bipartisan examples of the adoption of new laws and innovations. But to what extent are you seeing, or in your experience, are the particular laws that you're looking at resulting in a sort of balkanization as opposed to a sort of laboratories of democracy approach? And I was wondering if you could speak on the significance of that as we move into the next decade. And what effect do you think that'll have in terms of equality between citizens living in different states?
I think we are seeing a lot in polarization, and I mean, some of the innovations are so widespread they might not seem it like early voting, which you would then begin to see are some pullbacks in early voting. I mean, in some sense, the move to early voting. I mean, I think the era of intense polarization at the state level dealing with voting issues probably is ushered in after post-2000, and especially post-2010. And so a lot of early voting was adopted early, and it didn't necessarily connect liberal conservative valence. There were a lot of moderate and conservative states. My own state, the allegedly liberal state of New York, did not adopt early voting until last year. So we were an extremely late adopter. So I do think so. But then you begin to see a wave of cutbacks in early voting in the 2000s and 2010s, and as the states which had originally had been seemed less partisan, the states became more partisan, more polarized. So some of the no excuses absentee voting, that's nearly universal now. Almost all the states have something like that. But again, the question is, how are the mail-in ballots captured, and how does the litigation work out? So I think it's fair to say that some of the innovations are kind of cultural. And you do see, I think, places like Colorado and Oregon seem to be more experimental. Some of them might respond to distinctive state-level problems. I think it's not a coincidence that Maine was the first state to adopt ranked choice voting. Maine had a series of elections for governor and for the U.S. Senate where there was only a plurality winner, or at least in some instances it was pretty clear that the plurality winner would not have been the majority winner. But I do think there is a theme in terms of which states are doing what or which states are undoing what, and I think it does correlate with the general pattern of sort of blue states, red states, or most importantly, purple states, which have been, for the moment, governed as if they were red states.
So just to add a couple of points to that, I am struck at the extent to which over the last decade or so, reforms that might be characterized as pro-voter are thought to be left-leaning, and I wish that some political scientists could weigh in on this issue. I am not one, but I think there are loads of areas where pro-voter measures are not left-leaning or right-leaning, and voting by mail is one of them. And so I think that, which is kind of why I was struck with Judge Joe Flatt's dissent, saying we shouldn't allow anyone to vote by mail if the plaintiffs were to succeed. That would have resulted in the Republican losing more votes than the Democrat in that particular election. But somehow in our politics, the idea of pro-voter reforms has become associated with one party or the other. That is partly why I am encouraged by and supporting the bipartisan task force, Bipartisan Policy Center's election task force. There are a couple others out there that I think do a good job of pushing back on that and need our support to try to get these methods that are not to promote one party or the other, but rather to strengthen our democracy overall.
If the reason that people, I think that pro-voting things are left-leaning is that if everybody voted, Republicans would be in a permanent minority. And so there's an incentive to make voting hard, especially for young people, right? Long lines at college campuses, voter ID requirements where you have to have like an in-state license, but you just moved to the States, or how are you gonna get it, things like that. It's true that there are also voters who would benefit, who probably would be more likely to vote Republican, but I think that their calculation is that on net, it would affect it would bring in more kind of young people than it would. And people who like don't have IDs and things. I was talking to somebody earlier about that. The other thing is there's a fraud concern on the right? And so I've seen a lot about these like ballot bundling for vote by mail and things like that. I actually went and knocked doors for a candidate in California in the 2018 election, and we were told by the campaign, offer to take their ballots for them, right? And like they would have already been filled out, but I was so uncomfortable doing that, So anyway, there's a lot of concern that that would be kind of fraudulent too, and I think that that concern is much more on the right than on the left. Those are, I don't know, that's like, I don't know any studies on this, so.
Two more sentences just on that. You even see this showing up in very fine-grained ways. So in terms of what counts as government-issued photo ID, you will see in certain jurisdictions, hunting and fishing licenses, yes, university IDs, no. And you have a sense that that may reflect someone's judgment as how the people who have, that these are different voting pools. Similarly, in automatic voter registration or agency registration systems, some systems are just the DMV, and others are, involve, say, government welfare offices or other offices in which the clientele may be seen as somewhat different than people who just are getting driver's licenses. So that comes up as well.
Initially for Mr. Sells, but then also for the others. We heard to begin the program about the gerrymandering litigation. Voter ID has been very much in the press. But the right to cure your absentee ballot litigation was something certainly I was not as knowledgeable about. Looking ahead, sort of the next 4, 6, 8 years, but certainly this year, what are some of the other issues that have not been as widely reported that you see as potential litigation battlegrounds coming out of the 2020 election, 2020?
The left has filed a number of, you could say, preemptive lawsuits addressing some of those issues, led not exclusively, but in many cases by Perkins Coie and Mark Elias, who brought a lot before the 2018 election, and is a pretty well-known lawyer. They have focused on ballot order In other words, there's a political scientist finding that if your name is listed first, it is worth, I don't know, some number of points in an election. And a good number of states require that the Republican governor's party go first, or in many states.
I think they would say the governor's.
Governor's party. It tends to be red states that require that the governor's party goes first. Anyway, they get the ballot order advantage, and so Elias and company are challenging that. As I said, there are existing challenges to signature requirements in others, signature verification in other states. Where else? What else do I see on the horizon? Provisional ballot counting is something that I believe there could also be some litigation. And the issue there is if a voter is given a provisional ballot because they're not on the list of registered voters at precinct A and they should have gone to precinct B, do you throw out the entire ballot, or do you count it for, say, a presidential race where it doesn't matter whether they've cast a ballot in precinct A or precinct B? I think there is or is likely to be litigation on that front as well. I don't know whether it will be as successful as the verification litigation has been.
Only things I'm aware of that came up last time were polling place locations, particularly change polling place locations and how much discretion, which schools, which churches, which ones are open, which ones are closed, how convenient or inconvenient are they for voting by certain groups. Polling, sort of polling place size and machinery, and which places these often only will not come too late, but have very long lines, which versus not. Those are the main thing. There's one more thing I was thinking of, but I think it just dropped out of my head in addition to that. But I don't know if purge rules are still live after the Supreme Court decision, or whether there's still room to litigate about voter purge rules, or if you're a registered voter but you're inactive for some period of time, states will delist you. There's some mechanism to see whether you've moved or died or not, but often people don't respond to those postcards. So I think there may be some issues around voter purging. There's a massive voter purge litigation going on in Wisconsin right now about large numbers of people being. The problem is that many people will vote in the presidential election and not in any other elections, or they might have been particularly excited to vote a particular presidential election, say maybe 2012, and they were a little turned off about 2016. They may, under existing laws, may legitimately be kicked off the ballot, or they may be sent a postcard. Are you still alive, and do you still live where you used to live? And most of us who get those postcards just don't even look at them. Yeah.
I don't really know what the claim would be, but it wouldn't surprise me to see some litigation in the week after the presidential election, when a lot of states who do these vote-by-mail systems are very slow to report. So in California, you have to be postmarked on Election Day, right? And so this is resulting in something that Ned Foley at OSU has called the blue shift, right? Which is like, whatever the result is on election night, when the media all wants it, the ballots that are counted later tend to be more likely to be blue. And so it wouldn't surprise me if there's some litigation trying to get them to stop counting at some point, but I don't know what the claim would be on that. It just wouldn't surprise me to just see that happen for political purposes, that we filed a lawsuit, you know.
So we are going to have to continue the conversation over lunch, but please join me in thanking the panelists for a really thought-provoking.